Welcome to our second special group therapy edition of Called to the Bar, International Law Over Drinks, in which almost all of your usual hosts have gathered to discuss a topic of perennial concern. How do we teach something as sprawling, complex, and occasionally controversial as international law? In addition, recent announcements by one of Australia's major universities have stirred up once again the debate here in Australia about the extent to which education in the modern age should be online. To give that some context for international listeners, Adelaide University has announced that in the future, most students will no longer attend face-to-face lectures, which from 2026 will gradually be replaced by rich digital learning activities. Now, to be fair, Adelaide has stressed that this does not mean the abolition of timetabled on-campus face-to-face tutorials, workshops, practical studios, clinical activities, and forums. Nonetheless, we thought this announcement and its less than enthusiastic local reception provided a potentially useful jumping off point for a discussion about teaching international law online based on our own experiences across a number of institutions in Australia, the UK, and elsewhere. Today's conversation will feature me, Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, Associate Professors Ntina Tzouvala and Imogen Saunders, both of the Australian National University, and Dr. Tamsin Phillipa Paige of Deakin University. We would have loved to have our friend, colleague, and in-house procedure goblin, Dr. Juliet McIntyre of the University of South Australia with us too. Juliet, however, has been a bit unwell, and we all wish her a speedy recovery. But before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. And with that, noting the hour on a Thursday afternoon, what's your drink, everyone?
Okay, I'm happy to start on this one. I have, as my usual habit, a tea. This is a white, green, and oolong blend with a lot of dried marigold flowers and peach and ginger pieces. So it's a really very peachy tea blend that's still nice and low caffeine for me.
Peachy keen. Dina?
So I'm in Sydney where it's quite warm this afternoon. So I'm having a spiced pineapple soda mixed with some tonic and ice.
Wow, that sounds like a very refreshing non-alcoholic cocktail. Imogen?
I have drink envy listening to you guys because I have water in my ANU water bottle as I sit at my office to record this podcast.
Well, I'm also sitting at my office to record this podcast and forgot to make one of my usual teas from the Korean sampler box. And so I'm also drinking water, but I'm not drinking it from an ANU water bottle. I'm drinking it from a Republic of Indonesia Coast Guard water bottle that I was given after a training session once. No, Tamsin, just looking at the chat, I will not pause the podcast, come to the ANU, break into your office and steal a cup.
I was more talking about Imogen coming over and stealing a cup of tea from the pod in my office.
Oh, that makes far more sense. That would actually just be a walk around the horseshoe. Yeah. Okay. Probably funny enough to leave in the edit. Let's get into the actual topic of the day. So, teaching law is a tricky business. Many outside the discipline seem to think that as a professional degree, all we have to do is stuff our students' heads with facts and rules. But if that was the case, our students' education would be out of date the moment the law changed, which it does all the time. It's much more our job, at least in my view, to teach students how to think like lawyers, analyse problems like lawyers, and be able to use the law. As one book title puts it, what we teach is how to do things with rules. But turning innocent undergraduates into lawyers typically takes a whole 3 to 5 year degree. We expect them to assimilate the habits of mind of the profession through long immersion in the materials. So how then do we teach international law in a single introductory course? Essentially, in a program of sort of 10 to 20 weeks, depending on where you're teaching, we're attempting to convey the equivalent of an entire system of law: land and real property, contract, legal entities, civil procedure, criminal law, etc. And that would normally take, for a full system of law, years. So is that the basic challenge of teaching international law? How to teach students to think like international lawyers and how to do things with international rules and to do it in this really compressed frame? Or have I totally misidentified the basic pedagogical problem? Who'd like to take a first swing at this? Imogen.
Thanks, Doug. So for me, I think the challenge I find teaching international law is getting students to actually think of it as a system of law at all. We teach it here at ANU, we teach it as a compulsory, which isn't done in all institutions. And because of that, we teach it quite early. So we teach it in second year. And I think for us, our students are just getting their head around the concept of law in Australia by the time they come to international law. And then we introduce them to this other thing that is a bit similar, but also quite different in a lot of ways. And so we have that chestnut, is international law that we often start courses off by discussing. But at the same time, I think it is a challenge to get the students to realise that there are different systems of law, plurality of legal systems, and each of them can be equally valid even if they aren't identical. So for me, that's sort of the first hurdle to get over before we even start getting into the actual rules or how to think like an international lawyer.
Right. I have some empathy for that. I mean, the last time I really taught public international law as a compulsory to undergraduates was at UCL. And the analogy I'd always start with, I think I borrowed from Gary Simpson's On the Magic Mountain, which I think was one of the earlier articles I can recall reading on international law, about the analogy between international law and Indigenous legal systems, right? You can kind of say, well, you'll have encountered at some point, particularly in Australia, the idea of at least native title, if not other forms of Indigenous law. And what would you expect law to look like in a community of about 200 actors, most of whom are, kind of placed on a relatively even playing field in relation to each other? You wouldn't expect the centralized sort of systems that crop up with law. But anyway, Ntina.
Yes, I wanted to jump on this because I had a point that I think links directly to Imogen's, right? Which is, I don't start at all by pondering to this is international law. I don't discuss it at all unless some of them brings it up. The one thing I'm happy if they have understood a little bit by the end is to have assimilated the idea that this, like many other legal systems, as you alluded to, Doug, is a decentralized legal system for the most part, with certain exceptions, right? If they truly understand what this means, I think a lot of things in the law of treaties, in the law of state responsibility, for example, in countermeasures, in dispute settlement, they don't flow perhaps as a matter of logical necessity, but I think they flow as a matter of logical necessity plus history, right? You can build once you really understand what this means. Does it always work? No, it doesn't always work. But that's my main thread. I like having threads or stories through my teaching, and that's usually it. And the other thing I do, when you said, we have to teach them how to think like lawyers or international lawyers, I agree. Perhaps a slight variation would be, I tell my students also in non-international law that law is about knowing how to read and write, right? It's about a certain form of literacy. It's not literacy in plain English or plain French or plain Greek. It's literacy in a slightly different language. But I try to persuade them that if they learn to read and write following the particular style and conventions of this genre, they might not be amazing, but they would be good enough to make it up until a certain point.
Yeah, no, interesting. I used to start actually public international law lectures by asking, this was in the UK, how many people spoke a second language? And, a good number of hands would go up, most of the room. And then I'd say, okay, do you think you could learn a second language to speak it at a conversationally fluent level if all you did was listen to a podcast and read the phrase book? And everyone would just go, no, that's madness. And then I'd sort of point at myself as the lecturer and go, the podcast, and I'd point at the edited textbook and go, the phrase book. Unless you actually immerse yourself in the primary materials, you are not going to learn, or not even just the primary materials, the secondary readings. If you don't read stuff written by international lawyers, you're not going to get how to speak international law. Tamsin.
Yeah, I've got a few things to chime in here. I've had the benefit of teaching international law as a compulsory subject at ANU and at University of Adelaide. And now I teach it at Deakin as an elective, and it does lead to a few very different things. But I'll note on Dina's point of like language and what have you, I would say that if you would like to learn how to be an international lawyer, start substituting how with the way in which. Um, and but I also like I've made the argument on law is the common language of diplomacy in my work, and I do bring that through early when I start talking about sources in international law. And I'll say that teaching international law as an elective is much easier because the students have chosen to be there. And what I found at both Adelaide ran it in first year, second semester, and it was a disaster as far as I'm concerned. It was a really poor decision in scheduling. And the unit chair set a compulsory essay on Palestinian statehood for first year law students, and that was just an absolute nightmare to teach in. And so moving aside from that, ANU was a bit better, it was a bit better structured. But again, you had a room full of students who didn't understand why they were there. Why are we doing this? What's the point? And so it's a bit easier teaching it as an elective, even though I think it should be a compulsory subject. I would say it should be a compulsory subject in fact final year, or towards the end of the degree rather than towards the start. But moving on from that, in terms of how I structure it, I actually treat it as a foundation subject. So I had the advantage of getting paid through my PhD to teach a lot of foundations of law. And I actually start by saying, right, you've all done foundations of Australian law. You understand how law systems, this is foundations of international law. Forget everything you know about how the legal system works because you're learning a new legal system. And then I go through, rightio, what are our sources in this legal system? Okay, now that we've done that, let's look at detail at our two major sources, which is customs and treaties. And let's then look at all of the different key foundational premises in international law and saying, rightio, once you've got through this, then you can look at all the different sub areas of international law, like law of the sea or armed conflict or whatever. And I treat it as this is not going to make you an international lawyer. This will give you an idea about international law as a separate legal system that's horizontal in nature. It operates on consent with no centralized enforcement mechanisms, and which causes some consternation for students who are like, well, if there's no enforcement mechanisms, is it really law? And I literally say, well, how often do you have domestic law enforced? Like, what do you mean? I'm like, well, the vast majority of the population, the laws prohibiting murder work not because the police and courts enforce it, but because we all agree to not murder each other. And it's the same thing. And
Right,
so
exactly. Yeah.
it's the same. This whole idea of top-down law in domestic legal systems is utter horseshit.
Yep.
These laws in domestic systems all work because we all agree that maybe stealing each other's property and breaking into each other's houses and murdering each other is just bad for society, so we're not going to do it. Right. It never sees a court. It never sees police enforcement, yet we all follow it. Stop trying to tell me that this is an enforcement top-down based system. It's absolute, total fucking bullshit. But
just on that, I mean, back in the days when you'd occasionally see, actual live students carrying real physical newspapers, the example I would also kind of give is, when you've pushed your change across the counter at the newsagent, why does the newsagent actually give you the newspaper? And second year law students would go, oh, well, a contract has already occurred. There's been offer, exchange, acceptance, consideration, blah, blah, blah. And I'd be like, yeah, and, are you going to sue for your in conversion of goods for the unfulfilled for specific performance of a contract because you haven't been given a newspaper? No, of course not. The guy would just go out of business if he got a reputation for not giving people their newspapers after payment. Dina.
Just to jump on this, because I agree with you furiously. I think this has also something to do with the way most law schools in Australia, and I think also I can generalize, let's say, in the English-speaking common law world, teach domestic law, right? Because we teach usually domestic law, as Tamsin alluded to, as something that happens in courts and not even in courts as something that happens in appellate jurisdiction courts, right? And this is just such a tiny, 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 negligible percentage of legal, not just interactions, but even legal disputes, right? And I would say it's not just tiny, it's also tiny and skewed in many ways, as in people who encounter law through the welfare system or through the migration system or through policing don't usually all go to court because they don't have money and time and faith in the legal system to go to court, right? Their interactions are with, the welfare officer and the police officer, etc. So I just think it also tells you something about the way they are taught domestic law in a very court-centric manner, that I think it's also not necessarily a complete way of understanding domestic law.
I'd just like to give Imogen a chance to jump in on that, but I think we're already pulling out a theme here about the ways in which international law is different and has some unique foundations, but also actually in some ways more similar to a national system of law if we were to teach it differently. Imogen?
Yeah, I mean, I always find it funny in class when it's sort of a naivety sometimes, I think, of students, this idea that domestic law is followed as opposed to international law. You get the question of international law is breached all the time. So is domestic law, and the also idea that international law, and I think, all four of us definitely agree this, there is unequal power in international law, of course, and more powerful states treated differently by the system than smaller states. But again, that's the reality in domestic systems. Like this is not an international law problem. This is just the way the world works problem. And international law is just as susceptible to it. But I do think one of the things I was thinking about when Tamsin was speaking is I really like the idea of teaching international law at the beginning as a foundational course. And I think it's what we do. I mean, Dina and I both taught the same subject, following each other's year after year. So we know how the other approaches a subject. And I think really what we're doing mostly is we're teaching them structures, and we're teaching them where they can then later in their degree dive down into the content because they have the overarching structure and understanding of the system. And as we've said, they know the sources, they know how things work. The way at least we teach at the Australian National University, we don't actually teach that much substantive content the first time we teach international law. We touch on it a bit, but mostly we're about teaching the system. And then the purpose of electives later in the degree is to get down and drill into specific content in areas.
And I think that's actually a really valuable approach when you've got the bench depth that, say, the ANU does to teach multiple specialized fields of international law, because then you get into the problem that, the way a treaty is interpreted by a trade lawyer is not necessarily the way a treaty is interpreted by a law of the sea lawyer. I'd like to move us on, but just before we do, just for anyone who's sort of listening and coming at this for the first time and sort of saying, well, what does it mean that, a horizontal system of law is in some ways fundamentally different? When you're teaching law of the sea, which is obviously one of my core subjects, you get an easy way of explaining that, which I think still goes to the general case. So I'll just make the point, which is that you can kind of say underlying the development of the law of the sea, you've got two broad principles: a balance of interests and reciprocity. And the classic example is the width of the territorial sea, right? So there was a long debate as to whether the width of the territorial sea should be defined by a cannon shot rule or a fixed 3, 6, or 12 nautical miles. And eventually the number you come out at is said to represent a balance between what flag states will tolerate on the one hand in terms of the impairment of their navigation and what coastal states want in terms of control over resources. But the reciprocity bit is, of course, most coastal states are also flag states. So you've got to only be prepared to put rules out into the system that you are prepared to have invoked back against you, at least for most states. Superpowers can get away with ignoring the rules, perhaps, maybe not as much as they're often credited with, but for most medium-positioned players, reciprocity is important. Now, Tamsin.
Yeah, so very quickly, just to add before we do move on, picking up on what Dina said about people's interaction with the legal system, it's really, I'm doing some of my research is touching on social perceptions of law. And one of the things I found is that people see police and the law as synonymous, which I find absolutely wild and confronting. But the other one is when I'm teaching ethics, because that's my other course, I have to sit there and tell students that what they'll do day to day is really banal and routine and kind of boring often, but it's their client's whole life. Be it just a simple conveyance, be it succession planning, it's their client's whole life, and they need to treat it with that respect. And I think it's a really important point that we need to do better at teaching students in their legal degrees. And on Imogen's point, I do the same thing that you're doing with the teaching of international law, but I don't have the benefit of lots of international law electives at Deakin. So we kind of generally try and frame it as lots of options for their research essay in the degree so they can pick and choose something they're interested in, encouraging the ones who enjoyed it and do well in it to pursue honours in international law.
Terrific, thank you. Well, our next theme is controversy, essentially. And so before we get to the controversy about teaching online, I'd like to talk more about teaching controversial topics. So as Hilary Charlesworth, Sainted Hilary Charlesworth, blessed be her name, famously put it, international law is a discipline of crisis. As possibly her best-known quote goes, international lawyers revel in a good crisis. A crisis provides a focus for the development of the discipline, and it also allows international lawyers the sense that their work is of immediate, intense relevance. And in the 21st century alone, across roughly the course of our own adult lives teaching and researching international law, we've certainly seen a few. A non-exhaustive list would include the global war on terror, the invasion of Iraq and Afghanistan by the US and its allies, the Somali piracy crisis, crises in the legitimacy of investor-state dispute settlement and the functioning of the World Trade Organization, the South China Sea dispute, a seemingly unending civil war in Sudan, a crisis in the UN peacekeeping system with UN peacekeepers implicated in sexual violence in the Central African Republic and elsewhere, a seemingly brief-lived moment of crisis around the legitimacy of the International Criminal Court, the Russian invasions of Ukraine in 2014 and 2022, and most recently Hamas's attack in Israel on 7 October 2023, and the subsequent and now expanding, it seems, military assault on Palestine, both in Gaza and the West Bank, possibly now expanding further into Lebanon. And that is obviously an indicative, not an exhaustive list. But how do we deal with teaching controversies? Both those that seem to call into the question the very utility of our discipline and those on which students or some sections of the community may have deeply held views. Tamsin, I'll go to you first.
Yeah, so I'm going to say that I'm one of the few international lawyers who doesn't revel in a crisis. All of my research goes to the day-to-day banality of law. So I find crisis really frustrating because it derails the things I'm interested on, because now I have to sit there and tap the sign on why you can't just remove Russia from the Security Council and why you can't get rid of the veto. And it just annoys me. But on teaching controversies, I have a really interesting problem that relates to our second one, which is how we do our course delivery requires us to make sure our lectures are not incident specific and time specific. We have to keep them so that they can be watched out of sync and out of order or picked up again later without having them become irrelevant because they're speaking on a specific incident that's going to have developed. So teaching controversy, and that links to our next topic, which is the online teaching, because of Deakin's pedagogical techniques. But because of that, all of the teaching on controversy and things like that we do are in discussion-based classes. They don't occur in lectures, and they're in discussion boards. And so it becomes actually a lot more dynamic. There's a lot less of a potential for lecturer stating their views and students not having a place to input. It becomes a lot less about them absorbing my position and more about them raising the question and us engaging in a discussion, particularly We saw last summer teaching international law with the escalation in Palestine and the South African case and everything. Students putting in questions in the discussion boards that we were able to respond with, and other students chimed in, and it actually became a lot easier to teach those controversies that way, because I wasn't getting to engage with them from the pulpit of a lecture hall. I was having to engage with it in a discussion.
Thank you, Tamsin. I think that usefully goes to a couple of things. One, as a pedagogical technique, the virtue of sort of decentering the teacher, which I imagine we'll come back to, and also goes to a point that Alonso Gomendi made in our public engagement episode about, a generation in which students actually want their questions answered. They don't want to be passive recipients. And for everyone who wants to hear Tamsin tapping the sign about why you can't just randomly reform the veto on the Security Council and kick certain permanent members out, I would refer you back to episode 2, Security Council Shenanigans and Shirt Fronting the ICC Prosecutor.
And we will be organising another episode going through the reform in more detail, incoming once we've got that recorded.
It's a sign that requires repeated and, it seems, consistent tapping. And particularly when it goes back to the whole point you're making about students assimilating the law to the police, which again I find deeply, deeply shocking. But, that whole sense of, well, international law would work if only the Security Council did. And it's like, oh, you poor, sweet, innocent children. But anyway, I'm talking too much. Dina, Imogen, who wants to come in?
I'm happy to. I found that really, really fascinating, Tamsin, that idea of having to be so careful with the lectures in terms of not contextualising them in any particular time. I think I'd actually personally find it really difficult, because it's something I do without thinking about it. When I lecture, is you want to talk about what's going on. So, I think, but I mean, I can see the usefulness of it, but better you than me in terms of doing it. I don't think I'd be very good at it. One of the things, I guess there's a couple of things I wanted to say about this. One is, I do think it's important that we don't shy away from the controversy as teachers and as academics. I think we're all pretty lucky here in Australia that we're given quite a lot of academic freedom, and we're given support by our institutions and we're certainly never told we have to parrot a certain line or support a certain side. So I think there is openness given to us. But I also think, as a classroom manager and a teacher, we need to be really careful to make sure we create a safe space for our students in these discussions. We have all had students who are actually personally affected by these things, not just having deeply held views, but have family in conflict zones, or have other ties to these things that mean it's not just theory for them. And so one thing we need to do is just, it's what we'll talk about before. You've got to remember the people behind it. This isn't just a interesting point of international law. These are things that are affecting real people every day. And it's actually, I was thinking about this, it's funny because one of the things I've been doing every time I teach international law, every year I get more and more critical in terms of my approach to it. When I started off as a baby teacher, I was very much black letter, this is the law. And now, 15 years later, I'm just like, well, is it? I mean, really? And one of the things I do is, we talk a lot about context. And I think it's interesting because we have various like feminist projects and international law, and what a lot of those projects are doing are just reintroducing context. So there's a great book on feminist judgments, and I love the article on jurisdictional immunities, because the feminist rewriting just goes back and starts talking about the German prisoners of war who are actually, the French prisoners of war and Italian prisoners of war who are actually the genesis of the case, but have sort of actually disappeared by the time you get to the ICJ decision. They're not there. And so I think that context is sort of what I have in mind is when we get to these controversial topics, is that it's important to talk about, it's important with the students to discuss how the laws apply to them. It gives them real life context of the laws that we're talking about, which is great. But we also have to remember that this is personal and this is real, and it's not just a point of academic discussion.
No, thank you. That's a really valuable point, and certainly in all the institutions that we teach at or have taught at, we will have students with either those direct personal connections or, family connections at only one remove to events happening all over the world. Although that sort of point about the law also being personal, again, comes up when we're teaching things other than international law, right? Like if a student has experienced homelessness, they will have had encounters with the police and the system of private property and the administrative state that are all deeply personal as well. And all of us, I think, can fall into that trap of teaching things in a decontextualized way where things are just interesting abstract statements of the law. Just two sort of things I'd like to kind of flag as threads that we might pull on a bit more. The first is the idea of, how do you kind of prepare what might otherwise be lectured content, or in the words of Adelaide University, a rich digital experience that goes online and can kind of stand to some extent without instant context. I actually tried to do that sort of by accident teaching at Monash. I wanted to do more classroom discussion. So I sort of went, well, what's the most stable bits of the law of the sea I can discuss in outline in 20 minutes? And I pre-recorded these, and for reasons best known to them, my then employers allowed me to stick this on my personal YouTube channel, and they're still there, and I still get kind of feedback from people. Apparently they're quite big in the Philippines, where people just kind of say, oh, you're part of my course teaching materials, or I use your stuff all the time. And also that kind of just one sort of thing, though, that thing about we all become more critical of the materials we teach it over time, or at least certainly that's my experience. I do think, though, there's that difficult thing sometimes with international law about how do we teach students enough of the black letter formalism before we start explaining everything that's wrong with it. In a sense, you have to kind of let people become crits on their own time, right? You have to allow them to understand the system enough. And it's always one of those tricks about where do you teach theory of international law if it's a discrete section in a syllabus? Do you put it at the beginning so people can apply it as a lens to everything that they've done, or does it become kind of the detective movie aha reveal at the end where you go, no, the murderer was really, well, probably a global hegemon with an army. But anyway, Dina, before I lose my thread completely, or Imogen, come back in on that point.
I just wanted to jump in on that because I'm always amused. I did chemistry throughout high school and then at university. And every year they taught chemistry, they'd start with the base model of how electrons surround an atom, surround the nucleus. And you'd learn that base model. And then the next year they'd say, remember what we taught you last year? Yeah, that's not actually what works. This is how it looks. Then the next year they go, actually, no, last year, still not right. This is how it looks. And that kept going every year. I did chemistry right up to university. I don't know. I didn't end up majoring it. I don't know if I kept learning it, if they'd keep literally reinventing the atom as I went. But I think you're right, Douglas. We sort of do have to do that with international law. We've got to give them the base model, or give students time to understand the base model before we start saying, actually, that's not really how it works.
Very quickly on that point, I do it through delivering the black letter law through the required readings and the lecture content. And then I have an in-class assessment where students have to group present one of the recommended readings for that week. And every recommended reading is a critical reading of that topic.
That's a really interesting idea. Dina, did you want to come in on this?
Sure, thank you. So about the teaching of controversies, and then I'll go to the critique issue. I think there's two very useful pedagogical exercises also for us as teachers. One of it is to realize that depending on one's classroom, what is a controversial issue will differ. Right. And I think because very often we will enter the classroom with a very Eurocentric idea of what's a controversial issue. And for example, if you're teaching international law in Australia as an undergraduate versus as a postgraduate course, Palestine versus Taiwan would compete about what is more controversial, right? And I think it's a very interesting moment for me as well as a teacher when I will realize that what I have been thinking I have to be very careful about, and not teach, but be very careful on how I present it, is not actually what this audience has strong feelings about and strong opinions about. So that is one thing, because I think very often we come to these things through a very Eurocentric, basically, lens. So that is one. The second thing that I think goes to the discussion you guys have been having about teaching critique. Interestingly, what I have found in teaching public international law to undergrads is students are very receptive to a critique of international law that says it's hegemonic, it's racist, it's imperial, and less receptive to a critique that says it's not rules, it's stylized arguments. So basically, I find that they freak out much more with indeterminacy than they freak out with a critique of imperialism. And because by being a Crete, I'm also like just a little bit reactive. I'm just the thing everybody does. I want to do something else. It means that for me, I actually insist more on the critique of indeterminacy. I don't call it the critique of indeterminacy, but I tell them both about controversial and about non-controversial issues. The look, there is a range of arguments here that are all plausible depending on what things you accept to be true about international law as a legal order and also about the world, right? This range is very broad, but also some things are outside of this range. There are certain arguments that are simply not plausible within this legal system as we have them, in the same way that any language is very plastic, but there's many things that are simply wrong. That's just not how you speak English or Chinese or French. And therefore, even for controversial issues, but also for less controversial issues, I'm like, look, this is the range of things that you can say and people will not look at you like you're weird. This is the things that are outside this range. And I also tell them that this range does not coincide with justice and freedom and equality, because very often there will be students who will want to argue that this thing that they don't like in international politics, it's unlawful. Very often, that's a plausible move. But sometimes I'm like, this is not true, or perhaps this is not obviously true. And sometimes I have to be the person who's like, life is not fair. That doesn't mean we shouldn't make it fair, but maybe it isn't. So yeah, like that's the sort of like my 3-step move. Be open that controversy to my students is not what controversy is to me. Teaching international law in relationship to crisis as a range of plausible arguments, but also at least briefly raising the question whether this range of argument is politically, or for some people, other people would say normatively satisfactory.
Terrific. I'm just going to try and consolidate that a little, particularly for anyone who's not familiar with the critique of indeterminacy in public international law, because we can all just assume that. And I'm probably going to mangle it horribly, but once upon a time, there was this Finnish scholar called Martti Koskiniemi who wrote an extremely influential book called From Apology to Utopia, where he basically said that legal argument is slippery to the point of uselessness, if not indeterminacy, because it can only really ultimately do one of two things, or there are two poles that it vacillates between. One is utopia. You set out these wonderful international goals and ideals, but there's the risk that they'll never actually be implemented, because if you set a standard higher than states will accept, states and governments won't do it. Or you can have an international law that achieves nothing, because all it becomes is a way of saying that whatever governments are doing are legal. So you're caught. If international law, the horizontal system we've talked about before, is something that's only made by states and it's only law if states tolerate it, then how does the law have any meaningful influence on what states actually do? Can it constrain them, or does it just become a sort of political cover? And so everyone got terribly freaked out about indeterminacy for quite a long time. And Ntina, as you once put it to me over coffee, which I thought was the best kind of regrounding of that argument, was sort of like, sure, legal language is indeterminate, but it's not that indeterminate. And that takes us to the range of plausibility argument. There are always some things which, even if you can assemble something that looks a bit like a legal argument, 90% of practitioners are just going to go, that's bonkers. And Anne Orford, in her book, International Law and the Politics of History, talks to some extent about, international law as this sort of shared sense of conventions about how we use materials and the kind of conversations we're engaged in. But also, Kostyuk-Roberts recently has been writing on the idea of alternate legalities, where you have a series of baseline assumptions that are shared only by a limited community, usually a national one, from which you can build plausible-ish looking arguments if you accept those baseline propositions, but everyone else just looks at them and goes, what on earth are you talking about? So Russian justifications for the invasion of Ukraine probably fall into this bucket. A lot of Israeli scholars' approach to the question of what authority Palestine has as a state jurisdictionally over Israeli nationals seems to presume that there is no underlying Israeli state, that the Palestinian Authority was only delegated powers by Israel, which is just something that I think any other international lawyer would find very difficult to come at. And we've talked about this in a podcast with Kevin Heller. And also Chinese justifications about special historic rights in the South China Sea, or unique new rights of the law of the sea relating to archipelagos that benefit only them. All of these are, in a sense, parallel legalities. If you look at them from within inside that national consensus, they make sense. If you look at them from outside that national consensus, they seem very puzzling. Who wants to tell me I got all of that splendidly wrong?
No, I thought it was wonderful.
It sounded pretty on point to me. And on the note of Dina's comment about what's controversial for students might not be controversial for you, I basically caused riots in international law over summer by saying that Houthi attacks on maritime shipping weren't piracy because the Houthi were a functional government. So, I didn't expect that was going to be that controversial. Apparently it was.
And of course, we covered that in episode 5, which people can go back and listen to. All right, look, time is always against us. So I suggest we move on to where we said we were going to go from the start, really, online education. So I'm normally something of a techno-optimist when it comes to new technology and education. For example, I see ahead of us a bright, shiny future for education powered by AI, one in which students pretend to write their essays with AI, and we pretend to grade them with AI, and then everyone is forced after that arms race to move to seminar-based ungraded teaching and learning, my own personal paradise. But our particular topic today is how to make best use of online education. What are its potential and perils? After many of us, our forced experience with online education during the height of the pandemic and the lockdowns, coming off the back of that, does hybrid education work in practice? Are some cohorts of students better suited to it than others? There's a sharp divergence of opinion on the panel, though I imagine we'll find that we've got more in common than we think. But who would like to make a start?
I'm happy to let Dina, but I'd actually love to, as someone who,
please.
I'm in a really unique situation, and this requires some context. So Deakin, by founding statute, is required to provide every course that can be done by distance education through a distance education format, which means every course that doesn't have like in-person labs as a requirement must be taught through a distance format, which means that law at our university has an entirely online cohort. And so we've done courses where we run hybrid in-person ones, and we run in-person cohort alongside an online cohort where the live lectures are just recorded and put online for the distance students. And that is terrible. There is nothing more demoralizing as a lecturer walking into knowing you're teaching a 700 student course and walking into a lecture hall with 3 students because they're all going to watch the recording later. So knowing that we have to do everything via online education, I have actually amended all of my courses to have all of my lectures delivered by asynchronous pre-recorded videos, where I have 5 to 6 videos that are between 15 and 25 minutes long for each topic, and students, they're in a playlist. It's the same for distance and on campus students, and they can watch that in their own time with the expectation they've watched it before they get to their in-person discussion-based seminar that is face-to-face on campus for on-campus students and via Zoom for online students. So and this is fantastic. One of the reasons I went to Deakin is I'm very pro-accessible education. I didn't have it through my law degree, and it meant I just couldn't go to class, and I relied on textbooks and guesswork to get through because I had a burning need to eat, and that meant working full-time through my studies. So I am very pro online education, but it does require a different design to in-person education. And if you're going to run hybrid courses, you need to run it through separate streams. You need to not try and put the online students in the same classroom as the face-to-face students, because that's just bad for everyone. So you need to run an online distance stream and an in-person stream. Further complicating factor, and I'll need to caveat, I'm the JD director at Deakin, and the Deakin JD is online only. We have no face-to-face classes. It's online only. And we've been like that since we started about 8-9 years ago. So this is not a new thing for how we run it. And it works, but it doesn't work for everyone. And our biggest selling point is the flexibility of that education, and that our target market is students in their 30s and 40s looking to retrain for career shift, not undergrads. And what I have found from doing online education for 6 years is it's really good for students who are self-motivated and they will do the work. For students who aren't, they flounder and they struggle. But on the balance, I still think it's a good thing, and it's the thing that we should be doing. And I'm going to stop there.
Yep. Just a hard agree on that last point about online only can work really well for mid-career, highly motivated students. So my first experience of teaching online, which I documented to some extent in a blog post I can dig out and stick in the show notes during, which I first wrote during the COVID lockdowns. But my first experience of online only was here at UNSW Canberra, where our master's degrees historically have been online and remote only, because the target audience was mid-career defence and defence-adjacent personnel who could be anywhere in the world. And again, highly motivated people looking to kind of upskill or gain a particular qualification mid-career and knew what they were there for and why they were doing it. So I do think that kind of highly motivated mid-career or 30s, 40s cohort can do well in this environment, which goes to my earlier question about, does this work better for some cohorts than others? Ntina or Imogen, who would like to come in next?
Sure, I'm happy to get in here. So I think Tamsin's point already sets out some distinctions I think are crucial for me, which is I think there is a difference between universities that in a sense they have the facilities, They have the experience. Ideally, I would say they also have staff with proper training and can deliver education to a cohort, as Tamsin said, that otherwise, for reasons of socioeconomic reasons, for reasons of proximity or lack thereof, wouldn't have access to higher education or to these particular degrees. I think there is a distinction between online learning in this context and universities that, let's say, their undergraduate programs are mostly directed to domestic 18-year-olds that are basically doing switches to online because they don't have enough space, which is what is happening, right? I think these switches can have really big justifications, but I think it's the worst kept secret that Australian universities, especially those that are based in big cities, are running out of space. Some of it is because their management has decided, upper echelons of management has decided to run a real estate business with a side business of incidental provision of education, and that creates space issues. And the other issue that I think concerns me about this switch for universities that have not historically been doing it is what Tamsin kind of alluded to, which is, as an educator, I lose control over the products of my own labor. I didn't mention marks, but I think people can still take a shot. It's heavily implied. I think
Ntina said marks. Drink.
yes, like I do think it can be scabbing method, right? If everything becomes online and IP of the university, we as academic workers lose control over our ability to withhold our label, both individually and collectively, if the circumstances that necessitate that we do that, and we have very little other weapons, right? So that concerns me. And also it does concern me that, yeah, like these need for the content to be usable year after year makes it much harder to have lectures that address current issues in a way that is not opportunistic, but in a way that also, especially about international law, allows us to explain to our students why on earth this is important, right? So, but everything I say, and I really need to clarify this, does not apply to institutions that this has been their educational provision model from the beginning, in which I do think, in my experience, at least in Australia, perform a genuinely useful and a genuinely different functions to universities that historically have not been doing this, because historically they have been targeting. And because I also do think that there are ways of ensuring some level of accessibility without going fully online. It remains controversial, but the ANU does record lectures, in-person lectures, that then you can listen to as a podcast. It has all sorts of problems, but if push came to shove, if I had to decide between that and fully online delivery, I think I would opt for that. Yeah, so that's my take.
So Tamsin's got a clarifying question, but just before we go to that, I did law at the ANU in the 90s, frightening sentence, but anyway, and while there, I remember someone who was part of the academic union saying that they objected to their classes being recorded on cassette because they could see a future where this, wild and crazy technology would lead to the replacement of all lecturers, and everyone could just be fired, and there'd just be an audio bank of cassettes for people to listen to. Tamsin.
Yeah, so my question for Dina on your kind of distinction is, so you're saying that, say, I'm going to speak on, comparing our two different universities here or what have you. The Deakin, who have always been a distance education provider, we've always provided. Originally, back in the 70s, it was on cassettes sent out to students and they'd post back in their coursework and that. And now we've moved to online because that's how you do that sort of distance education. That the sort of methods I'm talking about, where everything's pre-recorded, to be used in that way, makes sense in that institutional environment. Whereas for, say, ANU or Adelaide, which is kind of that model of that campus experience university, that's a different context, and therefore our argument, our analysis of the issue becomes different because of that changing context.
Yes, and I just want to clarify, it doesn't need to be a sort of like, oh, historically certain universities has been doing A and historically have been doing B, because I think that can also be, in a sense, entrenching the distinctions between the GO8s and the rest. But I think it is a matter of universities deciding, either historically or currently, that, we are currently deciding that we are going to provide education to different cohorts of students, and these students on balance benefit more from some form of online education. And I'm agnostic about whether the modalities of Deakin or others are the ideal or not, right? I don't, but I'm saying that I think there is value, especially for 18-year-olds, for whom I think also the university has a socialization and civic education function. To be in the in-person lecture, I think, serves functions well beyond the communication of content.
Okay, so I have a question to kind of go on that. How then do you deal with students knowing they have access to a recording to that lecture, then opting to not attend for that? Because that's really hard on staff.
That's happening already. Here being the ANU. And look, my experience has been that, like, still enough students come to make it not ridiculous. I haven't personally felt that, like, I'm lecturing to people. I would say it's enough people to make it nice. I'm also very libertarian in terms of attendance. I'm really like, if you don't want to come, don't come. I want those who want to come to have the experience of the in-person or synchronous lecture. But I always tell my students, if you're going to come and like play with your phone the whole time, I truly prefer if you don't. It might not be because my answer might be conditioned by the fact that still at the ANU, at least enough people come to not be ridiculous. If I had experienced 30 people in the room, maybe I would consider this a bigger problem. And
not just 3 people in the room, 3 people in a 500-seat lecture hall.
Yeah, that's hideous and a horrible experience. So if I want to make sure we get to Imogen on this point, but just pulling a couple of things together, I think one of the things I'm sort of hearing here is that, we're not actually that ideologically polarized about any of this, right? There's the sense that it can be done well and it can be done badly. And the problem is a lot of universities are pivoting to this not because of well thought through pedagogical reasons, but because they operate in essentially an economy where they are, well, their only source of revenue really is taking students. And historically, everywhere I've taught, international students, although we're now entering a brave new world in Australia and potentially the UK, where there will be caps on the number of international students that can be brought in, which is a whole other thing. But the thing is, ultimately, universities as large organizations respond to the market incentives they're given. And if you have, as Dean has put it, your one of your principal functions seems to realistically to be acting more as a real estate trust at times rather than perhaps an educational institution, you wind up squaring the circle by going, oh, wait a minute, everyone tells us the lecture is dead, so now we can get rid of all of these big lecture rooms. Now, the best version of what Adelaide appears to be proposing would be to say, as Tams has been describing, we put the core content up in some sort of stable form online, and that replaces the lecture, but you still have potentially the in-person experience of a tutorial or seminar. And I could see that working really well. For me, the question is always, fit with cohort, what are the incentives for students to actually attend? The students are also operating in a market rational way, right? And how do we square the circle and do it in a pedagogically thought out way, rather than as a series of knee-jerk reactions that are rationalized later to look like pedagogical decisions? That's the end of my little rant. Imogen.
Thanks, Douglas. Time for my rant. I've got a few thoughts on this. Firstly, I think online teaching, when done badly, is just catastrophically bad. And I think the worst way you can do online teaching, and unfortunately we saw some of this during the pandemic, is you take a course that's been designed for in-person delivery and you just shove it online and you don't modify anything about it. And it's an awful experience for the lecturer. It's an awful experience for the students. And so I think maybe some of the resistance we have in academia to online teaching comes from that experience. I do actually share Dina's concerns about making our labour live beyond us and out of our control, because I don't think it's just financial concerns about space. I think it's also concerns about resources, that some universities want to have a bank up of resources that they can use without needing the academics. So I think that's part, maybe there's some of that concern. But I also think some of the pushback against online is just that academics often don't like change. I've had a serious conversation with people at the ANU lamenting that the tea trolley no longer comes around the corridors every afternoon like it used to. And I'm thinking, what decade are you living in? Because this is not a decade where any institution has money for a tea lady to come around every afternoon and knock on your door and offer you tea and cakes, as lovely as it would be. So I think there is that sort of, feeling of wanting things to be the same. And I did my undergraduate at UWA in the 2000s, and lectures weren't recorded then. And so if you didn't go to the lecture, you had to find a friend and hope they'd share your notes. And it meant that everyone was on campus most of the time. And so, have this very halcyon view of this wonderful on-campus experience that I think we worry our students will miss out on if they go fully online. And so for me, when I teach online, the biggest challenge is trying to build that cohort and trying to build that sense of community among the students that I'm teaching to. And you can't do that through lectures, obviously, but if you're doing small group teaching, seminars or tutorials, that's where you can do that. And I've actually had some of my favourite courses I've taught being ones that were always intended to be online. They didn't, get moved there unexpectedly. They were small groups, and it just worked really well. And even though everyone was scattered all over the world at that case, there was a feeling of a cohort by the time the course finished. And I think if you can do that, then the online experience can be really rewarding and valuable for the teacher and for the students as well. I do, though, think, and I agree with Dina, that I think there is some value to being on campus as well, in person. I take Tamsin's points about accessibility. It won't work for all students, but I do think that there is something about having a sort of universal physical space of learning, and where students don't just learn, but they talk and they organise and they protest and they do all those things that are much more than just learning the law, but are important about being at university. So I think my feeling is I would lament it if everything was online, but I certainly see the place for targeted online delivery if it's designed for that purpose and delivered that way.
I think Tamsin has something she wants to come in on, but just as well from me on that. Yes, my feelings about this are mixed, and some of it goes to the point Tamsin made before about, the economic realities of a lot of students, but also on Dina's point about, universities as a real estate hustle, one of the things that's obviously going to come in Australia is pressure for universities to build a lot more student housing, which for those who can afford to rent whatever it costs will probably increase the campus experience regardless of what happens with the rest of education. But I think in terms of the experience many of us had at university a certain period, a lot of that's been eroded not solely by students having to work or by students not seeing the point of coming to class. A lot of it's been eroded by the distance students now have to commute, right? Which I think has actually eroded a lot of community life in Australian cities, and I suspect elsewhere. Like if you're losing 2 hours a day or more just moving from A to B, that is time when you are not getting involved in a student society, a protest movement, or trying to form a study group because you missed the lecture and need someone to swap notes with. Tamsin.
Yeah, so I support the comments about on-campus education in principle. I never had that experience because I was one of the students who had an hour and a half commute each way and was working 60 hours a week because of a burning need to eat and not be homeless again. So I can't speak to the value of the campus experience. I'm less concerned about the recording issue from the experience at Deakin of how much students fucking riot if they feel that the lecture recordings are dated. And I've also found that because we're doing the recordings and because we know that student experience is king at Deakin, we get given lots of time in our workloads to keep these recordings updated regularly. So I'm actually less concerned about that issue than kind of Dina and Imogen on that, from the experience of the fact that if it's not updated every 2 to 3 years, students will lose their shit. And the university knows this. So things don't sit there as a bank of recordings.
So can I just say on that would appear to create a very strong incentive to preserve the value of one's labour, to dress in extremely of-the-minute clothing, or hold up kind of like a la a hostage video, like a dated newspaper at the beginning of all of your recordings to increase the likelihood that students will sort of see that this has been actually time-stamped and needs to be replaced. We, as ever, time is against us and we need to...
Can I just jump in there, Douglas?
Please.
Though last year I got very sick, I lost my voice, I couldn't lecture, and I had recordings from the year before for international law. And so I used them for that week because I just could not use my voice. But the problem was, in the recordings, my hair was bright blue. The year I was teaching the course, my hair was chin length and not bright blue. And I thought, the students are going to realise. The students are going to realise this is an old recording. You know, my hair can't grow that long in a week. No one said a thing.
Yeah, so on that note, it's less about the clothing dating, it's more the fact that they can kind of, there are things that they can just tell, and it's one of those things that, you know, because of that limitation, this is why I'm required to teach things in a timeless manner, because the expectation is they won't want to give me time to redo the recordings for about 2 to 3 years. But we also know that that's factored into our workload cycle. So it said I'm less concerned about that. But I also agree that, yeah, online learning needs a very separate design. And I'm really intentional about telling my students that online learning is isolating and they need to build community with their cohort to get through it well.
Right. Now, Dina's going to have to leave in a minute, and I'm also going to have to get home and check that my son is not indulging his newfound passion for baking without adult supervision. In any event, in wrapping up, we normally ask everyone a range of questions, but in lieu of time, I'll just stick to 2 of the classics: recommendations and escape routes. So who's got any reading, listening, or viewing recommendations for listeners on this kind of topic? And escape routes, very quickly, what is one thing you have been doing, reading, listening to, or viewing this last week that's taken your mind off international law? I saw Imogen's hand first in the auctioneer's fashion.
Mine's a quick escape route. This has got nothing to do with international law, and I've been loving it so much. It's a TV series called F-Boy Island. It is ridiculously bad. It's fantastic. And you can't think about anything else while you're watching it. So I highly recommend.
I've heard reports of you and my wife Zoe watching this while you were down with bad colds at the same time.
We did. We have a text thread of about 300 messages. My daughter was home, and that did result in me having to explain to a 9-year-old what an F-boy is. So parenting of the year there, but I still recommend the series.
Ntina.
Oh, it was about a reading for today's discussion. I have really enjoyed History and Self-Reflection in the Teaching of International Law by Henry Jones and Aoife O'Donoghue. It was published in 2022 by the London Review of International Law. It's freely available online. It's a great read for people who are interested in legal pedagogy, history, and critical approaches, sort of. And in terms of taking my mind off international law, I started doing Pilates, and you cannot think of anything else during the class because you're thinking, I am going to die. I'm dying. This hurts. So it really takes your mind off anything else.
Terrific. Well, in terms of escape routes, I've been doing a rewatch with the family of the TV series Loki, which is just a fantastic romp, and I think the best time travel sci-fi outside of Doctor Who, and on a good day, better than Doctor Who, which will obviously cause rioting in the streets. But I mean, the lead performances from Tom Hiddleston, Owen Wilson, and Sophia Di Martino are just delightful. And in terms of potential readings, there may have been some keyboard noise in the background, which I normally try and avoid in these recordings, because I was trying to remind myself of Jean-Pierre Gauci and Barry Sanders' book, Teaching International Law, Reflections on Pedagogical Practice in Context. But they also, if you Google hard enough, have a YouTube online seminar from the pandemic era where a number of the people who contributed to that book talk about teaching pedagogy and do so online. Tamsin.
On the note of teaching, I would recommend the International Law Multi-Perspective Approach Open Access textbook that I contributed a few chapters for. So I will say that at least 4 of those chapters are bangers, but it's a really good open access resource for teaching international law. And we've gone through some of the decisions that we made in terms of context in early stages of the textbook. So I'd thoroughly recommend that. In terms of escapes, everyone knows by now that I'm a keen golfer. I'm about to go on a 6-day, about a week off to go over to Adelaide to play in the South Australian Inclusive Championship, which will be fun. I'll play about 6 rounds of golf in 8 days. It'll be great fun. But also I have been now that I've got my hardware repaired, I'm doing a lot more DJing. Douglas, what are you wearing? Tell us all what you're wearing.
Oh, right. Yes. Okay. So I am wearing today a pair of grey wool trousers made by my local tailors with blue braces, a light blue shirt, a light blue wool jacket that I'm very fond of, and a brand new bow tie that probably looks purplish on screen, but is actually a dark background covered in light pink anchors. So a nice nautical theme, which I've paired with a pink pocket square with toucans on it.
I can confirm most of it sounds true.
Look, thank you, everyone. This clearly could have been a much longer, possibly multi-episode conversation, but I hope our listeners have found it as interesting and enriching as I have. And once again, we'll be back in your feeds and back in your ears in a week. So thank you very much. Bye-bye.
Thank you. Bye, everyone.
Thank you. Bye.